Good afternoon. This is Ron making fraud upon the court. The truth is in the details. Damron Construction Company / Stewart Title Guaranty Company, they filed a frivolous, fake, fraudulent complaint. Jerry Hill and Stewart Title and their lawyers perpetrated this conspiracy from the beginning. Okay? Damron / Stewart Title, they were not true plaintiffs. Their real role was defendants. This is a preempted strike, a fraudulent preempted strike to prevent us from being the plaintiff. We were the plaintiff. Damron them was the defendant without a defense. Judge Strickland and Judge Moore, findings of facts and conclusions of law, proved this 150%. They never was the plaintiff. Okay? It was a fraudulent, preempted strike perpetrated by State Attorney Jerry Hill and Stewart Title lawyers. So stay with me. The truth is in the details. Judge Moore, we all know Judge Moore. She made this material fraudulent misrepresentation that Ron and Gloria Mickens desired and sought rescission of the construction contract. Both parties on appeal agreed that this was a fraudulent misrepresentation, factually and legally incorrect for a number of reasons. Judge Moore also entered an order, unadjudicated order, without jurisdiction, ordering Ron and Gloria Mickens to pay Damron Construction Company for the cost of materials and labor. Damron Construction Company was found guilty of fraudulent misrepresenting the nature of a deed, fraud in the inducement of change, fraud in the execution of the deed, fraud in the formation and performance of the construction contract, fraudulently claiming and obtaining a claim to fee simple title to our property. He lost on all counts of their complaints, the Damrons. They were not entitled to any relief in equity or law. So, Judge Moore got to trick us. She's got to trick us. Okay? She already have started with that gigantic fraudulent misrepresentation that we desired rescission. So, okay, her next slide. She's going to order us to permit discovery. This is a trick. Okay? Ordering us to permit discovery. We've already had discovery. Discovery was before pre-trial conferences and trial. The record has already been established. This trick is to get us to give our consent to participate in this so-called court-ordered inspection of property or court order to permit discovery for us to vacate or to replace or abort 25 or more undisputable and undeniable claims that we are going to prevail on as a matter of law in exchange for one claim where we got to pay the losing parties, paying the losing parties. Now, who in their right mind would participate in something like that? 25 undeniable and undisputable claims in exchange for one claim. I hope you see the trick. Okay? This is fraud upon the court. But get this, I'm going to share this with you. The Damrons / Stewart Title, they oppose this fraudulent order also. And I'm going to share with you their cross appeal. They said the court erred when it failed to award damages supported by the record and directed the parties to submit additional evidence. The prior appeal of this cause resulted in the reversal of the prior final judgment and remand to the trial court for entry of a new judgment, which is supported by the record. In other words, Judge Strickland's fraudulent, own personal, unique judgment was unsupported by the record. His order was unsupported by the pleadings, unsupported by the evidence, and objected to by both parties. So this is why we both appeal. The cause was not remanded for a new trial, nor was it remanded with instructions to take additional evidence. The remand was simply limited to entry of a judgment supported by the record. Neither Damron nor the Mickens asked for an opportunity to submit additional evidence on damages. By directing the submission of such evidence, the lower court erred by exceeding the scope of the remand. This court has clearly recognized that no principle of appellate jurisdiction is more firmly established than the one which provides that a trial court ultimately lacks the power to deviate from the terms of an appellate mandate. In addition to being beyond the scope of this court's mandate, the evidentiary hearing ordered by the lower court was and is unnecessary with regards to the existing record. They're just saying we've already had discovery. We've already had pre-trial conference. We've already had a trial. This is to bring in this fraudulent evidence to support a cause of action for rescission. Now, we're not going to, sure, we're going to object to this. And so did the Damrons them. Damrons them could not invoke her jurisdiction for no permission to inspect property or permission to inspect property or permit to discovery. Okay, and we certainly want. So this brings on Judge Goldstein. Like I told you in the past, Judge Goldstein was their man. Okay, so stay with me. Judge Goldstein fraudulently, from the beginning, separated the case. The case had been consolidated. The three lawsuits had been consolidated by Judge Durant and Judge Prince. Now, Judge Goldstein is going to fraudulently unseparate, divide a case that is inextricably tied together. Alan Damron, Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, and Highsmith, they conspired and agreed to commit fraud together. They fraudulently made a deed to our property. They fraudulently encumbered our property with a mortgage. They fraudulently converted our title. They fraudulently slandered our title. They committed organized fraud, schemed to the fraud, forgery, okay, building houses under false pretenses. They was inextricably tied together. They were interconnected. They were entwined, okay, joined. But here Judge Goldstein is going to divide the case, fraudulently misrepresenting that they were distinct, independent cases. Distinct. In other words, based on this fraudulent pretext that they were not tied together, that they were not joined, that they were not intertwined, that they were not interrelated, they were not integrated. Fraud had been alleged in all three lawsuits. Damron had been named in all three lawsuits. The case, the lawsuits, was all predicated on the same operative facts. So, Judge Goldstein is committing fraud upon the court. He ordered the clerk of court to maintain the three lawsuits in three separate files on one hand. On the other hand, he ordered and required us to style the pleading as if all three of the courts, all three of the lawsuits was consolidated. Okay? He got to fraudulently so-called divide these parties into separate independent parties to give them these frivolous, fraudulent judgments. So here we go. He's going to grant the Damrons a sanctioned judgment talking about we fail to permit discovery. Check this out. The Damrons opposed this fraudulent order by Judge Moore, and by him now, I just read you Damron's them cross appeal. They agreed that this was an unlawful order. Now, check this slave mentality out on their part. They say court ordered to permit discovery. That's not permission. Permission means that you have the right to say no or yes. If you're going to say we have we have the right to give our consent. Consent means that we have the right to volunteer or not to volunteer. Are you going to court order us to give our consent? You got to remember, this is a trick to induce us into vacating, set aside, replacing our 25 claims or more in exchange for one claim. So please stay with me, because this is just fraud upon the court. And he's going to give them a judgment based on an accusation. Based on an accusation that somebody, somewhere, we don't know who, so-called caused Damron them not to inspect the property. How you going to give Damron them a judgment based on an order that they objected to? The same as we objected to. He gave us no sanctioned judgment against them. That don't make any sense. But he's trying to fake as if Damron them is a separate party. All of these parties is necessary and indispensable. They're tied together into one suit. And our Judge Artiglaire ruled the same way. He said what Judge Constein was doing was regrettable. Okay? Now, after he granted Damron this fraudulent $234,854.67 fraudulent sanction judgment against us, they dropped the Damrons from the lawsuits, from the case. Now, in exchange for dropping Damron, Stewart Title Guaranty Company gonna drop their fraudulent, frivolous foreclosure against Damron. Remember, Damron and Stewart Title are co-conspirators. They have a subrogation agreement, an insurance agreement. Okay, Stewart Title don't have a cause of action against anybody. The mortgage was invalid. That's why they paid it off with insurance proceeds for total title failure. They ain't got no cause of action against Ron and Gloria. In other words, they cannot allege that we were in a mortgage with anybody and that we failed to pay a mortgage. Okay, this is just fraud on their part. No standings, no right to sue, no cause of action. But guess what? Judge Constein entered a $202,000 foreclosure judgment against Ron and Gloria Mickens. Now, done dropped the foreclosure action against the fraudulent, mortgagee in exchange for a fraudulent fake warranty deed. Now, Damron has been found guilty of fraud, but now he's able, outside the suit, to transfer the property to Stewart Title Guaranty Company. Okay, you see why Sheriff Grady Judge them is covering up and protecting the criminal today after being found guilty of fraud by Judge Strickland and Judge Moore. Okay, but it don't stop there. Judge Constein them create and fabricate something called a trial order. This trial order is is being put together to reverse the findings of facts and conclusions of law that Judge Strickland, the trial judge, and Judge Moore found against the Damron. They fraudulently fabricate, they mischaracterize, and they all kinds of misrepresentation to defame, to libel and slander, to stigmatize us, Ron and Gloria Mickey. You've never seen anything like it before in your life. And guess what? Damron, how you gonna reverse findings against Damron and they ain't even part of the suit? They ain't even part of the litigation anymore. Okay, let me just say, when the Second District Court of Appeal refused to obey their own order, they gave these lawyers in Stewart Title them the authority to run amok against us. They exploited the Second District Court of Appeal's bias and prejudices against us. Second District Court of Appeal affirmed rescission. In the first appeal, Second District Court of Appeal ruled that they could not affirm a judgment unsupported by the plea, unsupported by the record, objected to by both parties. But they did it with rescission and direct contradiction of their previous orders. And then they allowed the lower court to disobey their mandate. This so-called order to permit discovery was outside the scope of their own mandate. So you got to know, they were all doing this for the blood money. So they had the license to do whatever they choose to destroy us. They treated us like slaves. We was high-tech lynched, okay? We were treated inhuman. We were just, 3/5 human, whatever you want to call it. They were like barbarians, okay? Stacking up fraudulent evidence, fraudulent orders for the sheriff and sheriff's SWAT team to carry out against us. And as you know, it doesn't stop there because Federal District Court and the 11th Circuit gonna write up frivolous and fraudulent orders just like Judge Cohnstein. Oh, they just sticking the deck on us with all these fraudulent orders. Now you can understand what I mean when I say one lie leads to another lie. They all have to be part of the conspiracy. So you can see, because what? The truth is in the details. The truth is in the details. I have this memorandum of law just to remind you. Under federal law, which is applicable to all states, the U.S. Supreme Court stated that if a court is without authority, its judgments and orders are regarded as nullities. They are not voidable, but simply void, and form no bar to a recovery sought, even prior to a reversal in opposition to them. They constitute no justification, and all persons concerned in executing such judgments as sentences are considered in law as trespassers of the law. This is what the sheriff and the judges are doing. They provided with the unlawful theft of our property in direct contradiction to the trial judge findings of facts and conclusions of law on the merits of our fraud, cancellation, deed, quiet title, ejectment, and breach of contract actions. This is a demonstration of institutionalized racism where injustice has been purchased. Okay? Why else would they be doing this? So you got to stay with me. Okay? Stay with me. In the words of Elaine P. in order to correct wrongs, you have to shine the light of truth upon them. Your truth is in the details. You got to subscribe. You got to share. Okay? you got to share. So that's it for now. But I'm coming back. I promise you that. I'll talk to you later. Bye.